Good morning, everyone. I'd like to take attendance for those members of Convocation who are attending by phone. When I call your name,
no longer in lecture mode.
when I call your name, would you please indicate that you're present? Robert Armstrong,
Good morning, President.
Constance Backhouse,
Present.
Larry Bannock.
He's present in the room.
Thanks, Larry. Paul Copeland. Paul Copeland. Seymour Epstein.
Present. Paul Copeland, I'm present.
Thank you. Seymour Epstein. Lawrence Eustace.
I'm here.
Patrick Furlong.
Here.
Virginia McLean.
Here.
Jan Richardson.
Present.
Heather Ross.
Present.
Catherine Strasberg.
Present.
Bradley Wright.
Here.
James Scarfone.
Here.
Is there anyone on the phone whose name I have not called?
Mark Sandler.
I'm sorry?
Mark Sandler.
Mark Sandler. Thank you, Mr. Sandler. Anyone else?
Ronald James.
Ronald Maines. Anyone else? All right.
Roger Uketti is here.
Thank you, Mr. Uketti. Anyone else?
Hunter.
Sorry?
George Hunter.
Thank you, Mr. Hunter. Anyone else? All right.
The conference is in lecture mode.
So before turning to the business at hand, I'd like to review the instructions for the phone system for those participating by phone. Once we determine who is on the telephone, I will let everyone know that we'll be placing those calling into the meeting in what we call lecture mode. This means that from our end, we are muting all callers, and once muted, they will be able to hear the meeting but cannot speak. We, of course, will need to come out of lecture mode to hear callers who wish to speak, and we will do that as the day progresses with the speakers list. Unless callers wish to speak, I ask that they *6 their telephones as we have done in the past, and we will repeat this procedure throughout Convocation as necessary. I have one additional bit of business to deal with today, not anticipated, but it comes as a result of a happy event for one of our venture colleagues. As you know from the memorandum from the Secretary, Robert Wadden was appointed a judge of the Ontario Court of Justice last week. On behalf of Convocation, I congratulate Justice Wadden on his appointment and wish him well as he begins his career on the bench in Ottawa. This appointment has created a vacancy for a bencher in the electoral region outside of metropolitan Toronto, and we have a motion before us at tab 5, tab 6, to elect Peter Festeriga from Leamington as a bencher. The motion before Convocation is moved by Adriana Doyle and seconded by Ross Earnshaw. Any discussion? All in favor of the motion? Opposed, if any? Carried. Mr. Festeriga will be joining us on April 24th when I will give him a more fulsome introduction. I know you will extend a warm welcome to him at that time. On behalf of Convocation, I also wish to congratulate the 5 paralegal benchers who were elected on March 31st and took office yesterday. Robert Bird, Kathy Corsetti, Michelle Haig, Brian Laurie, and Marion Lippa. Welcome. For most of you, welcome back to Convocation. Before we begin the deliberations respecting Trinity Western University, I want to take this opportunity to review today's procedures. Before that, however, I would like to acknowledge 3 individuals who are joining us today in Convocation Room Bob Kuhn, the President and Vice Chancellor of Trinity Western University. Janet F. Buckingham, LLC Director and Associate Professor of Political Studies and History at Trinity Western University. And Eugene Meehan of Supreme Advocacy LLP Ottawa, Counsel to Trinity Western University. TWU is the applicant seeking accreditation. Its representatives are here today as observers only and will not be participating in our discussions. They will have the opportunity to provide a written response following this convocation, for convocation on April the 24th, and to address convocation at that time. As you know, we are webcasting convocation today and on April the 24th, so that anyone who wishes can view our convocation proceedings from their desktop computer. For those benchers who are following the debate on the telephone and were thinking of also watching the webcast, you should know there is a 60-second delay, and as a result I suggest you do not try to follow the webcast, or at least mute the volume if you do. In addition, some rooms have been set aside here at the Law Society for lawyers, paralegals, and members of the public to watch the webcast. Today, these individuals are in the upper and lower barristers' lounges, and on April the 24th will be in the Lamont Learning Center. On February 27, 2014, I advised convocation of the process we would follow in determining the Law Society's accreditation of TWU. A copy of my statement is available on the Law Society's website and on board books at tab 1. I don't intend to repeat that statement here. In a few moments, Ms. Freya Christensen, who is acting as counsel to the Law Society on this matter, will provide convocation with some overview information and will refer to some of the issues I addressed in my February statement. Ms. Christensen is a partner at Cavalluzzo, Shilton, McIntyre, Cornish LLP, Toronto, where she practices administrative law and civil litigation. Welcome to convocation. Before Ms. Christensen speaks, however, I would like to highlight the material that is before convocation and a few points from my February statement to remind convocation of certain procedural issues. As you know, there are 2 convocations scheduled to consider the Trinity Western University accreditation. Today we will begin the Law Society's consideration of the TWU matter. We will not be voting today. Today's meeting is to give benchers the opportunity to raise any questions or concerns they have relevant to the issues before them. As I mentioned earlier, TWU will be given the opportunity to respond in writing to the issues and concerns raised today prior to April the 24th. We will complete our consideration of this issue on April the 24th at regular convocation, after which convocation will vote in answer to the question. And as set out in my February statement, I would ask the Secretary, Mr. Varro, to read the question that convocation will answer on April the 24th. Mr. Varro.
Thank you, Treasurer. Treasurer and benchers, the question to be put to convocation is as follows. Given that the Federation Approval Committee has provided conditional approval to the Trinity Western University Law Program in accordance with processes convocation approved in 2010, respecting the national requirement, and in 2011, respecting the approval of law school academic requirements, should the Law Society of Upper Canada now accredit Trinity Western University pursuant to Section 7 of Bylaw 4.
The material before you includes material provided by TWU, background reports from the Federation of Law Societies and the Law Society relevant to the issue, other materials such as statutes and bylaws, and all of the submissions the Law Society received before the deadline of March 28th. All of the material is posted on our website on the dedicated TWU page. We have also posted the equivalent of the convocation material that benchers have through their board books on our convocation page on the website, so that all page references are identical for anyone using the web version of the material. To ensure the integrity of the process, I again ask benchers to keep in mind, one, that during the course of convocation today and on April the 24th, benchers should not use social media either by sending or receiving communications on the issues being considered. Two, that benchers should refrain, excuse me, I'm just going to take a moment to reconnect the phones.
Welcome to TELUS conferencing. To join the conference, enter your access code followed by the number sign. At the tone, please state your name, followed by the number sign.
Convocation. Hello, is anyone on the phone, please?
The conference is no longer in lecture mode. The conference is in lecture mode.
All right, so to ensure the integrity of the process, I ask benchers to keep in mind, one, that during the course of convocation today on April the 24th, benchers should not use social media, either by sending or receiving communications on the issues being considered. Two, that they should refrain from expressing their views or considering additional submissions they may receive following today's convocation. And three, that they should refrain from reaching a final view until the decision is made on April 24th. I appreciate that many benchers will wish to speak during today's convocation and convocation on April the 24th. And as you can see by looking around the room, there are many benchers in attendance today and a number participating on the phone. And although we have scheduled an all-day convocation today, in the interest of the process operating fairly and effectively, I'm just going to set out a few guidelines. I will, as I do at every convocation, be creating a speakers list. While I am not setting a time limit for speaking, I am imploring benchers, perhaps, to use their best efforts to be on point and concise in their remarks. I will not recognize benchers to speak a second time as long as there remain benchers who have not yet spoken for a first time. If you're recognized to speak a second time, please use the additional time for any new information or questions you may have. I will be encouraging benchers to keep any second opportunity to speak to a few minutes only. I ask benchers to consider not repeating at length points that have already been made by others. We'll take the morning break and afternoon breaks at appropriate times, and we'll break for lunch at 12:30. I would now ask Freya Christensen to address convocation.
Thank you, Treasurer and members of Convocation. I have been asked to advise Convocation on the procedural fairness of the process for considering the TWU accreditation application. The process has been designed to provide the requisite degree of procedural fairness to TWU as an applicant whose rights, privileges, or interests will be affected by Convocation's decision. As the Baker case has established, the values underlying the duty of procedural fairness relate to the principle that the individual or individuals affected should have the opportunity to present their case fully and fairly and have a decision made affecting their rights, interests, or privileges made using a fair, impartial, and open process appropriate to the statutory, institutional, and social context of the decision. The decision is one to be made by Convocation in its deliberative capacity. It will be made by majority vote. Those are the elements of the statutory scheme. There are no bylaws or regulations setting out a different process. Under the Law Society Act, you have a very broad discretion, which must be exercised in a manner consistent with the statutory scheme, including the purposes and the principles set out in the Act and in accordance with your determination of the public interest. It is very different than a judicial or quasi-judicial decision. The SPPA does not apply to Convocation's decision. As a result, I advise that the common law of procedural fairness will be met through the process you are engaged in and which I will highlight today. The decision will be made primarily on the basis of a written record by way of written hearing. TWU will be given notice of Convocation's concerns through the questions and statements you make today. TWU will have an opportunity to respond, both orally and in writing, before the vote on April 24th. After hearing TWU's response, you will deliberate in public and vote on April 24th. The reasons of Convocation will be provided through the transcript of both sessions, as well as the written record and ultimately the vote. I will now briefly expand on the key elements of procedural fairness. The first aspect is the written record and the primarily written hearing. The Treasurer set the question announced in Convocation on February 27th. TWU made an application in response to the question on April 2nd. The submission is at tab 2.1, page 7 of the board book. Convocation has also received public submissions on the question contained at tab 4. The Society received 210 submissions in response to the invitation for submissions. You have also been provided with 3 legal memos, which are intended to provide guidance to you in the exercise of your discretion. I have provided a memorandum, a letter, providing you with guidance on discretion and the public interest. This is at tab 3.2.4, page 1852 of your board book. Mahmoud Jamal of Oster, Hoskin and Harcourt LLP has provided guidance on the application of the Charter and Charter values to your decision-making process. And that is set out at tab 3.2.3, page 1836. Finally, Andrew Pinto of Pinto Ray James LLP has provided guidance on the application of the Ontario Human Rights Code and human rights values to your decision-making process. That is at tab 3.2.5, page 1878. TWU may choose to comment on or respond to this guidance before the vote. The 3 guidance memos have been made public and are posted on the website. The Federation of Law Societies of Canada materials also form part of the record. The Federation's Approval Committee report is at tab 3.1.1, page 737 of your board book. The Federation's Approval Committee has given conditional approval to TWU's program based on meeting the national requirement. This society participated in that process as a member of the Federation. Law Society staff have provided a background report on the national requirement with links, or the full contents, and that background on the national requirement is at tab 3.2.1, page 1264 of the board book. I can advise that TWU likely has a legitimate expectation that the Federation's process for approval of the academic requirement, the process adopted by Convocation, will not be disturbed by Convocation. The Federation's Special Advisory Committee report is at tab 3.1.2, page 1017, and the 30 submissions received by the Federation commence at tab 3.1.3, page 1063. TWU took part in the Federation's academic requirement approval process, as did the Society. However, the Federation process did not and could not answer the question of whether it is in the public interest in Ontario to accredit or refuse to accredit TWU. Only you can answer that question, and that is the question you are answering in the present process. Law Society staff have also provided a background report on mobility, tab 3.2.2, page 1742 of your board books, and other relevant materials which are often referred to in the submissions and the other matters are the Charter, the Human Rights Code, and the TWU Community Covenant. So those background materials are posted at tab 3.3, commencing at page 1924. So that essentially is the written record to date. And that's one element of our procedural fairness. The second aspect of procedural fairness is notice to TWU of any concerns or questions that Convocation may have. And that is the purpose of today. The procedural fairness requirement is that notice be given of your concerns so that TWU can make a meaningful response. This is the first convocation since the question was set and since the submissions were received. As decision makers, you have reviewed those submissions, and today you are to raise your questions and your concerns that you believe are relevant to the exercise of your discretion. TWU's counsel and representatives are here today, and they will listen to the issues that you raise. They will also receive a transcript of today's proceedings, and it is on the basis of the concerns that you raise today that they will prepare their response. And that takes me to the third aspect of procedural fairness, which is the right to make a meaningful response. TWU will be given the opportunity to respond in writing by April 22nd. TWU will also be given the opportunity to make oral submissions on April 24th. The fourth aspect I will comment on is reasons which have specifically been raised by TWU. I advise you that if there is such a duty, in this case, the duty to give reasons will be reflected in the public deliberative decision-making process, which takes place in the context of the vote on April 24th. Convocation will be held in public. Your decision process will be held in public, and a majority vote reflecting the will of Convocation will determine the outcome. In the case of an elected body, the question of reasons has to be determined in the context of the statutory, institutional, and social context of the decision-making process in which you are engaged. It is distinct from an adjudicative process before an administrative tribunal subject to the SPPA. The majority vote is the decision. So the record, the transcripts of today, and the transcripts of April 24th will act as a sufficient surrogate for formal written reasons, so that the purpose of reasons, that TWU as applicant or a reviewing court can understand the rationale behind your decision. The entire proceedings will be transcribed, and this meets the requirement for reasons in this statutory and institutional context. The fifth and final aspect of procedural fairness I will comment on today is that you are a body which is and must remain impartial. You must keep an open mind today. You must keep an open mind when you review the response by TWU, the written response by April 22nd, and the oral submissions on the 24th. You are then to exercise your vote once you have considered the complete record, including that response. You may and you are expected to raise concerns today, whether as statements or questions. You are raising those concerns today so that TWU can respond, so that you can have TWU's answers to your questions or TWU's position with respect to your concerns before you vote. Your concerns expressed today, however, should not be the final expression of an opinion which cannot be changed. Rather, this is your opportunity as decision makers to raise for TWU the questions and issues you see relevant to your discretionary decision. Once TWU has completed its response on April 24th, the hearing portion will end. You will then begin your deliberations on the question. After you hear from TWU on the 24th, then you will have to make up your mind on the question and vote. Until that time, you have to keep an open mind. Treasurer, that is my advice with respect to procedural fairness, and I thank you for the opportunity to address Convocation.
Thank you for your assistance, Ms. Christensen. I now have started the speakers list, and Mr. McKenzie is first on the list. I'm going to ask Mr. McKenzie to go to the podium, followed by Ms. Leeper and Mr. McDowell and Mr. Anand.
Thank you very much, Treasurer. I want to address a couple of process issues, and I want to discuss the decision that we have to make on April 24th on the merits. But first of all, let me start, Treasurer, if I may, by commending you and your advisors for the process that you've developed for the Convocation's consideration of this important and difficult issue. This could have been dealt with in a much more nonchalant way that I personally have found very helpful. The submissions that we received, that we invited, and also I found very helpful the legal advice that we've received about the various issues, including from Ms. Christensen. And I do think it's very important that we honor her admonition and yours, Treasurer, that we keep an open mind about this and listen carefully before coming to a firm conclusion as to how we will vote. I and others will be expressing strong views today, I expect, on the issues, but I don't think any of us should consider those to be conclusive views until we have an opportunity to vote. I wanted to address the process that was adopted at the Federation level. I do think that it's important that we, like other law societies, have been moving towards the development of national standards in different areas, such as rules of professional conduct, but certainly also in the area of establishing uniform national standards on questions of academic matters and entry-level competence. And I think insofar as the recommendation of the approval committee of the Federation is concerned on Trinity Western University's compliance with those standards of entry-level competence, we should give great deference to those standards because we believe in national standards and it's in the public interest that we have national standards. But I do think there's an important distinction to be made between national standards of entry-level competence on the one hand and questions of core values on the other. And the process that was followed by the Federation in this unique case with the establishment of a special committee to express advice, and it was advice only, it was an advisory function that the special committee served, to provide advice on whether there were other issues was an extraordinary process, and it goes again to the question of values. And those values are different, they're important, and they're core values that we subscribe to here. The decision that we have to make as to whether to accredit Trinity Western University is ours to make. We didn't delegate questions of values to the Federation. The other comment that I'd like to make with respect to the Federation's process and its reports is that the special committee that was set up to provide advice with respect to matters other than academic or entry-level competence qualifications focused to what I found to be a surprising degree on the decision in the British Columbia College of Teachers case a number of years ago. That's certainly a consideration that we should weigh, but I think we have to keep in mind that we are not an inferior court. We're not bound by a doctrine of stare decisis. We have a very different function under our bylaws in deciding whether to accredit a university proposing to provide a law school education. And so I think that consideration is one of limited interest to us in our deliberations today and on April 24th. That case may be distinguishable, and I'm not going to get into an analysis of the reasons and whether there are reasons to distinguish yet from the present case. Others have done so in their submissions. I do think that it bears mention that there is probably no issue on which public attitudes have changed more in the last 15 years or so than the question of public attitudes towards discrimination based on sexual discrimination. And there have been intervening events that may well lead to a different legal conclusion today than was formed by the Supreme Court of Canada in the BC CT case when it was decided, perhaps most importantly, the enactment in 2005 of the Civil Marriage Act, which recognizes the legitimacy of same-sex marriage throughout Canada. I also found it interesting, before I leave this subject, that there was a dissenting judgment in the BC College of Teachers case as well from Madam Justice LaRue DeBay, who mentioned the decision that the U.S. Supreme Court came to in the mid-1980s in Bob Jones University case. In that case, the issue that the U.S. Supreme Court had to face was whether a university that discriminated based on race, in the sense that they had a equivalent, I suppose, of a community covenant that prohibited interracial dating and interracial marriage, was entitled to tax advantages. Now, I think perhaps we can draw a useful analogy between public attitudes towards interracial dating and interracial marriage in 1985 and discrimination based on sexual orientation in 2014. And I find that a useful analogy. Now, there is no issue on which, in my view, we have made greater progress in our profession and in the Law Society specifically during my time as a bencher than matters of equity through the establishment of our Equity and Aboriginal Issues Committee and its work over the years, through the establishment of our Equity Advisory Group, through the work of our Equity Department under Jose Bouchard's leadership. But I think perhaps the most important development in that area at the Law Society for our purposes is our adoption of a rule of professional conduct, which says that lawyers have a special responsibility to honor the obligation not to discriminate on grounds that include sexual orientation. Lawyers who contravene that rule of professional conduct may be disciplined by the Law Society. If that's a rule of professional conduct that we require all lawyers to comply with, how can it not be a rule that we must honor ourselves? And that leads me to the question, finally, that we must answer here. I don't think any of us should disagree with the approval committee's finding that Trinity Western University has a curriculum that complies with our requirements nationally for entry-level competence. But I do have a very considerable concern about the questions of values that is raised by the community covenant requirement, which in my respectful submission must be discriminatory on the basis of sexual orientation. I, for one, would feel comfortable granting conditional approval to Trinity Western University, the condition being that its community covenant be at least amended in such a way that it does not discriminate on grounds of sexual orientation. And if Trinity Western University is unwilling to comply with that condition, I'm afraid the answer to the question that's posed in convocation today must be no. Thank you very much for your attention.
Thank you, Mr. Mackenzie. Ms. Leeper.
Thank you, Treasurer. Good morning. I wish to acknowledge the presence of Trinity Western representatives and thank you for attending in person. Questions. TWU publicly endorses 6 core values. The first of these is to obey the authority of Scripture by embracing all that the Bible teaches regarding faith, ethical commitments, and way of life, believing this to be the ultimate standard of truth. So, my questions arising from this are as follows. Is the TWU Community Covenant an example of the ethical commitments mentioned in the core values? If so, is it anticipated that those ethical commitments, and by extension the Community Covenant, will form a critical or any part of the pedagogy of the law program planned for TWU? Could TWU expand on the relationship between this expression of values and ethical commitments and the curriculum? And if not, why not? Are there areas of public law, including human rights legislation, Charter of Rights jurisprudence, for example, that TWU would anticipate conflicting with the scriptural sources of ethical commitment among its students? How would these conflicts be resolved? And finally, given that there is no impediment to teaching law at TWU, and the question before us relates to accreditation in Ontario of graduates from TWU, can TWU assist us in understanding the relationship between offering an accredited program and religious practice or activity? How does that differ from the relationship between the teaching of law without accreditation and religious practice? Thank you, Chair.
Thank you, Ms. Leeper. Mr. McDowell.
Thank you, Treasurer, and I, again, want to thank our guests for coming. I'm here to listen to my colleagues and ultimately to TWU. I haven't made up my mind. I have some explicit questions that I'll come to at the end. But I'm inclined to believe that we must accredit TWU. And like all of you, I have found coming to this tentative view agonizing. No matter what we decide, it will be contended by the losing side that we have violated fundamental rights. And I'm deeply uncomfortable with the community covenant. Now, many submissions to us have taken the view that we are in breach of our obligations should we accredit TWU. It is said that there is a clash of rights. The society itself will have violated the Law Society Act. We will have acted inconsistently with our duties as individual lawyers, as I gather I seem to be doing by making these tentative submissions, and that we will have violated the Charter. The Advocate Society has taken this view. Let's take a TV time out here.
I'm sorry, Mr. McDowell. We have to reconnect with the phone system. Maybe we should take a commercial break and ask what our service provider is. Take that.
Ask for another one.
Welcome to teleconferencing. To join the conference, enter your access code followed by the number sign. At the tone, please state your name, followed by the number sign.
Convocation.
The conference is no longer in lecture mode. The conference is in lecture mode.
Mr. McDowell, I'm sorry.
Treasurer, hopefully we can count that as injury time. As I was saying, from my reading, the weight of the submissions we have received tilts heavily in favor of the view that we should not accredit. Opponents contend that in 2014 such a clash of rights can only be resolved in one way. The changes in social norms, the evolution of the social context means that the rights of LGBT persons must trump any right to freedom of expression and religion supposed to be expressed by the community covenant. All of us understand the emotional force of this argument. Canada has led the world in not just legalizing but embracing the legitimacy of same-sex marriage. We've had same-sex marriage in Canada since the Halpern case in 2003. It is a right that has been hard-won by LGBT persons through the Supreme Court's decision and the marriage reference decision, and ultimately the Marriage Preference Act. None of this came easily. In the lead up to the Supreme Court reference, the federal government itself had argued that permitting same-sex marriage would be destructive of the nuclear family as the building block of Canadian society. But in the twinkling of an eye, the federal crown itself had reversed its position, and it was right to do so. In the reference, the Supreme Court declined to rule on an important aspect of the case because the Martin government intended to introduce same-sex legislation, whatever the court said. The vote on the legislation was close, but it passed. Same-sex marriage has blossomed in Canada. The sky has not fallen. Heterosexual marriage as a social institution continues to thrive. LGBT people in Canada are accepted in every sphere of our society, and certainly in our profession. Same-sex marriage is now recognized by 23 of the United States, the intelligent states, as Bill Maher calls them. The recognition of the rights of LGBT persons is without question the greatest social transformation of my lifetime. So surely it must follow that an institution like TWU, which fails to move with the times, get with the program, accept what our courts have recognized, what Parliament has recognized, what our provincial human rights codes recognize, cannot possibly grant degrees, which the Law Society should recognize. My friend Mark Berlin from the Department of Justice is a married gay man who's taught for years at the University of Ottawa and McGill. He asks point blank, how can you even consider accrediting such a place in 2014? But I adopt the submission of the BC Civil Liberties Association. We are convinced that one group's rights to equality and non-discrimination cannot be bought at the price of intolerance for the fundamental freedoms of others. I say that as a matter of law, we cannot accept that the Section 15 rights of LGBT persons trump the freedom of religion rights enjoyed by the community of TWU. If we vote to accredit, we are accepting that members of a religious institution whose views we do not hold are nevertheless free to join us in the fellowship of the bar. We may profoundly reject their views. In a free society and in our profession, we have to live with the idea that some of our colleagues hold repugnant views. On the other hand, should we decline to accredit, we at the Law Society will not have injured Trinity Western so much, but we will have voted to bar students from our profession because they are adherents of a faith who have agreed to live by a certain code. The sad history of the struggle of minority religious groups trying to enter our profession within living memory warns us that we should not go that way. My friends say the focus must be on the institution. TWU applicants won't be admitted, but they won't be admitted because they went to a non-accredited law school. But Mr. Ron Corelli lost his business because he was stripped of his license. The question is still what lies behind the denial of accreditation. The Supreme Court has repeatedly renounced the notion that there exists any hierarchy of rights in the Charter. To the greatest extent possible, the court has told us rights should be reconciled and not prioritized. The balanced rights not only protects the rights of individual Canadians, it allows Canada to function as a diverse and plural society. The Federation was forged as a compromise not only of language rights, but equally so of religious rights. Now, many years ago, Governor Mario Cuomo addressed the challenges of religious rights and pluralism in a famous speech at Notre Dame. And he said, "The Catholic public official lives the political truth most Catholics through most of American history have accepted and insisted on. The truth that to assure our freedom, we must allow others the same freedom, even if occasionally it produces conduct by them which we would hold to be sinful. I protect my right," said Governor Cuomo, "to be a Catholic by preserving your right to believe as a Jew, a Protestant, or a non-believer, or as anything else you choose. We know that the price of seeking to force our beliefs on others is that they might someday force theirs on us." Many in this debate have reminded us of remarks of Chief Justice Dixon in Big M Drug Mart about the essence of freedom of religion, the right to entertain religious beliefs as a person chooses to declare them openly without fear of hindrance or reprisal, and so on, but also the need to balance where other fundamental rights are threatened. There is a clear and unbroken line of authority which expands on this proposition. Last year in Whatcott, the Supreme Court said, "We are therefore required to balance fundamental values underlying freedom of expression and later freedom of religion in the context in which they are invoked, with competing charter rights and values essential to a free and democratic society, in this case a commitment to equality, respect for group identity, and inherent dignity over all human beings." The limit to exercise freedom of religion lies where the religious practices or beliefs would cause harm. As the Supreme Court said in TWU 2001, the line is drawn between belief and conduct. Does the exercise of freedom of expression of religion cause objective societal harm? In this instance, is there a risk that TWU lawyers will discriminate against LGBT people or will otherwise harm them should they be called to the bar? It does not seem to me that the focus on likelihood of actual harm or risk of harm as a limit to rights has shifted in our jurisprudence. In Whatcott, the Supreme Court re-emphasized the broad protections afforded to freedom of religion. The court warned of the mistaken propensity to focus on the nature of the ideas expressed rather than the likely effects of the expression. And I think it's important to say that no one in this debate seems to be saying that TWU is hate-mongering. Nevertheless, the community covenant is troubling for the reasons that many submissions have pointed out. As the Advocate Society says, the covenant forbids students from same-sex marriage and is said to be necessary to ensure the integrity of the TWU community. This does seem to suggest that even associating with LGBT people at TWU would affect the integrity of TWU. The covenant misses the point that sexual expression is not what LGBT people do, it is at the core of who they are. Equally repugnant is the notion that TWU students are expected to inform on one another if there are breaches of the covenant. If TWU will not treat its covenant simply as a matter of conscience, then it becomes dangerously intrusive. If the state has no place in the bedrooms of the nation, I really wonder, covenant or not, whether university administrators belong there either. But we have to put this in context. TWU is a private religious university. It is a faith community. It has a comprehensive faith-based set of rules. It is not a public university, much less an arm of the state. I say that the rules of the covenant are not imposed on anybody. They are accepted by those students who choose to join the faith community and attend TWU. I accept in saying that for a host of reasons, some will feel unable to sign the covenant and will feel practically excluded. I note a partial exemption from the provisions of the Human Rights Code of British Columbia. Under 2A of the Charter, Trinity Western must have the right to determine conditions for membership in accordance with its shared religious beliefs. This is how faith communities survive. It is for the individual to decide whether or not to sign the covenant or whether or not to abide by the rules having accepted them. It's not for the Law Society to pass judgment on the covenant or on any other religious tenet. For that reason, permitting law graduates from TWU to become lawyers in Ontario pursuant to the Law Society Act does not, it seems to me, suggest that the Law Society endorses the view that LGBT Canadians are less worthy of respect than others. Should we accredit TWU, we will be seen to have accepted the evaluation of the Federation Approvals Committee. We will be seen to have respected the freedom of those who wish to govern their own conduct in accordance with the religious tenets of the Trinity Covenant. The Supreme Court said in the first case, TWU is not for everybody. It's designed to address the needs of people who share a number of religious convictions. And this next passage is important. To state that the voluntary adoption of a code of conduct based on a person's own religious beliefs in a private institution is sufficient to engage Section 15 would be inconsistent with freedom of conscience and religion which coexist. Now, I know I'm sailing into a bit of a stiff breeze here, and I've taken note of many of the objections. One is that the whole legal context, as Mr. Mackenzie says, has evolved since the first Trinity Western case. This amounts to a contention that whatever the Charter says in Section 2A, freedom of religion, is no longer fashionable in the courts given the inexorable sweep of history. A number of submissions contended that the test for equality jurisprudence has evolved since 2001. Promotion of the dignity of all citizens and the goal of substantive equality is, it is said, and should be the main consideration for the courts. Leaving aside what got, several thoughts come to mind. One is that freedom of conscience and religion remain, by the terms of the Charter itself, fundamental freedoms. Parliament had this firmly in mind when it adopted same-sex marriage. The Civil Marriage Act of 2005, which guaranteed same-sex marriage, also preserved and protected the right of Canadians to disagree about the legitimacy of marriage within their religious beliefs. 3.1 reads, "For greater certainty, no person or organization shall be deprived of any benefit or subject to any obligation or sanction under any law of the Parliament of Canada solely by reason of their exercise in respect of marriage between persons of the same sex or the freedom of conscience and religion guaranteed under the Canadian Charter of Rights and Freedoms, or by the expression of their beliefs in respect of marriage as the union of a man and a woman to the exclusion of all others, based on that guaranteed freedom." This is how we as Canadians have and must reconcile competing rights and values surrounding same-sex marriage. And I say that this provision of a quasi-constitutional statute in my submission makes analogies to racial discrimination in Bob Jones University inapt. Secondly, even if the judicial context has changed, how does barring graduates who have agreed to live by the Trinity Covenant from a regulated profession promote the dignity of all citizens and the goal of substantive equality? Third, accepting that the court might not rule the same way in 2014 on TWU, is that for us to say, or is it for the court subsequently to say? Now, a number of submissions have expressed the view that because Trinity students will be taught from a fixed evangelical point of view, they will receive an inadequate legal education. I leave those submissions aside because I don't sense that that will be the focus of our debate. I leave issues surrounding the adequacy of Trinity Western's teaching and academic freedom for another day, because I say we have a firewall to protect against these concerns, and that is our oath, which we take seriously. Whatever legal education our candidates have gotten, we are bound by our oath. It says in part the following: "I will protect and defend the rights and interests of such persons as may employ me. I shall seek to ensure access to justice and access to legal services. I shall champion the rule of law and safeguard the rights and freedoms of all persons. Whether our graduates come to us from Thompson Rivers or the University of Toronto, this is our covenant. We don't vet our lawyers' beliefs, but we do hold them to these standards. In a country as vast and diverse as ours, this is surely where we draw the line." Now, I do have some questions, and these arise from the Pinto opinion, and I appreciate Trinity Western's position that Ontario Human Rights Code principles have nothing to do with what we do here. But like a court, I'd say if we imagine that they do have relevance for our exercise of the public interest jurisdictions we have, should that change our analysis, and I draw their attention in particular to questions 1 to 9 at page 22 of the Pinto opinion. Because it does seem to me that, notwithstanding everything I've said here, if the lens is the questions that are in that part of the Pinto opinion, it may change our analysis. And a further question would be, to the extent that that analysis is inconsistent with the charter jurisprudence, which I've reviewed, does the charter nonetheless prevail, given that it's Section 52 of the Constitution Act says it's the supreme law of Canada? So, Treasurer, I don't know how tentative that sounded, but that really is my tentative view. Thank you very much.
Thank you, Mr. McDowell. We're going to wait again for the phones to be reconnected. And then Mr. Anand will be up next. Mr. Anand, could you just go to the podium, please?
You want me to go ahead?
No. If you could just give us a moment, Mr. Anand.
Welcome to teleconferencing. To join the conference, enter your access code followed by the number sign. At the tone, please state your name followed by the number sign.
Convocation.
The conference is no longer in lecture mode.
Hello? Hello, I'm just making sure people are on. Thank you, thank you. We're going into lecture mode
We
again.
were cut off for quite some time.
Yes, that's right.
We're having trouble.
We're connected again. We're connected again, thank you.
The conference is in lecture mode.
Mr. Anand, please.
Thank you, Treasurer. Let me too personally extend our welcome and our greetings to our guests. Some have suggested that Convocation's decision on TWU's accreditation application has been made by the Federation's Canadian Common Law Program Approval Committee, and that equality issues have no place in the determination by our law society. Some also say that the decision has been dictated by the National Mobility Agreement or by the Agreement on Internal Trade. Respectfully, I beg to differ. While I think these factors have to be given careful consideration, I want to outline my thinking on these issues at this point and ask a number of questions that, in my view, must be satisfactorily answered before accreditation of TWU can be granted. Convocation is required to make a discretionary decision on whether to accredit Trinity Western University under sections 4.1, 4.2, 27 sub 3, 62.02, 4.1 of the Law Society Act, and our bylaw 4. In making its decision, Convocation is guided by these provisions and by the quasi-constitutional Ontario Human Rights Code and the constitutional Canadian Charter of Rights and Freedoms. The Law Society is required to consider all relevant sources of law, including the guideposts contained in the Law Society Act and the Code and the Charter. Convocation is required to exercise its discretion in accordance with the Law Society Act's purposes and principles and in a manner consistent with the fundamental values of the Code and the Charter. So I want to consider these legal requirements in turn. Section 4.1 of the Law Society Act sets out the purposes of the Law Society including ensuring that persons practicing law in Ontario meet standards of learning, professional competence, and professional conduct. The Act authorizes the making of bylaws prescribing qualifications and requirements for licensing in Ontario, and pursuant to that power, Bylaw 4 says to receive a license to practice law in Ontario, an applicant must have a degree from an accredited Canadian law school or a certificate of qualification from the NCA. An accredited law school is defined in Section 7 of our bylaw, and a law school that is accredited by our law society. So the Law Society's statutory authority to accredit Canadian law schools has not been supplanted. Section 32 of the National Mobility Agreement provides that a signatory governing body will require no further qualifications for a member of another governing body to be eligible for membership than the following. A, entitlement to practice law in the lawyer's home jurisdiction. B, good character and fitness to be a lawyer. C, any other qualifications that ordinarily apply for lawyers to be entitled to practice law in its jurisdiction, that is, this province. So there's no doubt, in my view, that for an individual to be entitled to practice and for us to decide that, the legislation and regulations of Ontario are incorporated and binding, including the requirement that the Canadian Law School be accredited in Ontario by this law society. Nor, in my view, is the Law Society's authority displaced by Section 7 or Chapter 7 of the Agreement on Internal Trade. Under that agreement, a jurisdiction can impose additional requirements to certify a worker who is certified elsewhere in Canada if those additional requirements are in the service of a legitimate objective. The determination of legitimate objective is made at the receiving governmental level, in this case in Ontario, under the laws of Ontario. So again, we're back to the Law Society Act, the Human Rights Code, and the Charter. While the Ontario Mobility Act obviously has statutory force, it must yield to the quasi-constitutional code and the constitutional charter to the extent of any inconsistency. So we return to the seminal provisions that govern this issue, and they are in Section 4.2 of the Law Society Act. That in exercising our powers to accredit a Canadian law school, the Law Society has a duty to maintain and advance the cause of justice and the rule of law. And the Law Society has a duty to protect the public interest. In exercising our discretionary statutory authority, Convocation therefore has a positive duty to determine and act in accordance with the public interest, the cause of justice, and the rule of law. Indeed, in the precise context of lawyer licensing, our cross-committee working group on the Federation's suitability to practice standards said just a few months ago in a submission that was adopted by Convocation that under one of the 4 behaviors for good character, which was respect for the rule of law and the administration of justice, specific reference to respect for and adherence to human rights and equality principles sends an important message to those entering the legal profession. More generally, our Law Society is proud of its equity initiatives, as Mr. McKenzie said, and its advocacy in support of inclusion and non-discrimination in areas that include sexual orientation, gender equality, and marital status. The Law Society's Equity Initiative Department actively supports and promotes adherence to equity principles in legal organizations, including law firms, and in its own backyard. Consideration of human rights principles is therefore required for the Law Society to comply with its home or constituting statute. Moreover, the rule of law, the public interest, and the cause of justice surely mandate that the Law Society will act in accordance with these overriding external enactments, most notably the guarantees of equality. Quite independently, Supreme Court jurisprudence within the last decade has made clear that every administrative decision maker with the power to decide questions such as this is obliged to consider and take into account the Human Rights Code and the Charter. Tranche-Fontaine determined that statutory human rights issues are not relegated to human rights tribunals, and indeed, we often take the Human Rights Code into account in our tribunal cases at this Law Society, and in making accommodations for licensing examinations. In Martin and Lesueur, the Supreme Court made the same decision in relation to the Charter. And the Law Society is obviously subject to the Constitution as a body itself exercising powers conferred by statute. All of this to say is to say that human rights issues and charter values of non-discrimination must form part of our decision today. And indeed, if there were any doubt, the Supreme Court explicitly said that in the context of Trinity Western in the 2001 case, that the College of Teachers in BC had the jurisdiction to consider discriminatory practices in its determination of Trinity Western's application. Mr. Laskin's opinion for the Federation and the Special Advisory Committee in its consideration of TWU's law school application reached the same conclusion. More recently, the Supreme Court in Dore has held that administrative decision makers must act consistently with the values underlying the grant of discretion, including charter values. In disciplining a lawyer, the Barreau du Québec was obliged to balance the public interest in lawyer integrity and conduct with the lawyer's charter right to free expression. So Convocation, in making its discretionary decision, must balance and give effect to its statutory objectives, as well as overriding charter values and non-discrimination rights. The TWU application has been presented as a clash of fundamental rights. To the students' and faculty's freedom of religion on the one hand, and a host of non-discrimination rights on the other, in terms of sexual orientation, in terms of marital status, principally. TWU is a private university based on evangelical Christian principles and beliefs that is not subject to the charter on its own, and it may benefit from exemptions and defenses to non-discrimination rights that are generally available under the BC Human Rights Code. On its face, the covenant that students and faculty are required to sign annually is prima facie discriminatory against LGBTQ students and faculty and on unmarried persons in common law relationships. That's discrimination on grounds of sexual orientation and marital status unless the adverse impact is exempted by the code. And we know, and it's been stated, that conflicts of protected rights are to be reconciled to the extent possible by impairing each set of rights to the minimal extent necessary. In the 2001 TWU case, the Supreme Court focused on the allegation that education graduates of TWU would be ill-equipped to serve as teachers. The court balanced competing rights on the facts before it. We will have to focus, however, on what's different about this case and what has changed in the meantime. Number one, the Supreme Court relied on the BC legislature's approval of the TWU requirements. I question whether that's relevant here since we're operating under Ontario law. Two, the Supreme Court relied on what it called the burden that the BC College of Teachers decision placed on a particular religious group, preventing them from expressing freely their religious beliefs and associating to put them into practice. I don't know if this is even relevant to the decision of Ontario's Law Society not to accredit a law school in another province. Three, as has been noted, the Supreme Court relied on a correctness standard of judicial review. Recent jurisprudence suggests a reasonableness standard in terms of reviewing a decision such as ours that would lessen the prospects of a court overturning our decision if the proper statutory and human rights considerations are taken into account, as I'm confident they will be. 4, clearly the last decade has seen an evolution in social values, again this has been referred to, concerning the importance of providing substantive equality to a vulnerable minority based on sexual orientation. The central determination in the earlier case was that the court required proof of harm inflicted by TWU graduate teachers. I question whether that determination was consistent with other Supreme Court jurisprudence that would rely on the impact of the covenant on the dignity and self-respect of individuals, plain and simple. Indeed, is it good law after the Supreme Court's decision in Watcott, another decision that balanced fundamentalist religious rights against non-discrimination based on sexual orientation? More important is the earlier case in the Supreme Court binding on us with our independent mandate to make a discretionary decision in the public interest, taking account of and following the rule of law and the cause of justice. Fifth point with respect to the earlier TWU case, in the Watcott case and in several human rights tribunal decisions since then in different jurisdictions across the country, adjudicators have refused to draw a distinction between the prohibition of homosexuals on the one side and the prohibition of homosexual activity on the other. This would appear to be another reason to reject the American Bar Association approach. Operating in an environment that includes many private religious universities, unlike Canada, the ABA settlement appears to accredit law schools with covenants such as TWU's on condition that admission of LGBTQ applicants is not prohibited. Is this not an impoverished conception of equality, inconsistent with our more robust human rights jurisprudence that focuses on dignity and respect? A gay or lesbian student is not required to hide his or her sexual orientation and sign a document that is contrary to his or her values in order to pursue a legal education. If I've captured the situation accurately, the human rights term that captures the situation of the gay or lesbian student would be poisoned educational environment. More importantly, the ABA accreditation criterion seems unworkable. For TWU to come within the defense under Section 18 of our Human Rights Code, under the Divisional Court decision in Christian Horizons, which has been referred to in one of the opinions, which dealt with the parallel Section 24 defense, TWU would have to prove that the teaching of law furthered the religious purposes of the university and its members, that law students were attending TWU to obtain a religious legal education. Whether or not that can be proven, that's quite a different perspective than we would look for as a secular institution in accrediting TWU. But do we need to draw the balance of competing values in TWU's employment and student restrictions at all? Rather, should we accept that TWU is operating within BC law as a private educational institution, but ask ourselves a different question: whether our public interest, rule of law, cause of justice mandate in Ontario should be exercised in its favor? And in that context, there are a number of additional questions that I believe must be answered and with which I'll close. Does it accord with the rule of law, the public interest, and the cause of justice for Convocation to accredit a law school which seeks to promote and advance what are acknowledged to be genuine minority religious beliefs, but in doing so requires exclusionary policies that harm the interests of several segments of society, those coming within the very large groups that are covered, marital status and sexual orientation prominently? Does it Can accreditation be reconciled with our Law Society's long-standing and abiding commitment to promote equity and diversity in the legal professions? These are interests which must be protected by the Law Society, a secular institution that serves a diverse Ontario society in which gays and lesbians are entitled to participate fully and openly in all aspects of society. Does it advance the cause of justice and the rule of law for the Law Society to provide its imprimatur to an institution which reserves required educational opportunities to enter into the practice of law to a small segment of the population, and concurrently decreases the proportionate opportunities available to a historical disadvantaged group, members of the vulnerable LGBTQ communities? Will our Law Society, if it accredits TWU, violate Section 9 of the Ontario Human Rights Code, which prohibits a body from discriminating directly or indirectly if an applicant to TWU is denied admission because of the covenant? Does accreditation implicate the Law Society, a secular and public institution, in adopting or assisting in what would undoubtedly be discriminatory policies in a public institution such as ours, and thereby violate the Human Rights Code and the Charter that govern us quite independently of TWU? I hope further discussion and response will answer these troubling questions.
Thank you, Mr. Anand. On the speakers list next is Mr. Mercer, followed by Mr. Shavis, Ms. Hare, and Mr. Ruby. And, all right, and I've got some hands up, so I'll
I propose to principally address just one aspect of the question before convocation. I do so hoping that our discussions and subsequent submission by TWU will clarify and challenge my current thinking. Specifically, I want to address what is relevant for the purpose of our exercise of our discretion prior to consideration of charter values and human rights code issues. It's my view that it's too easy in this discussion to leap to those discussions, not that they're not important, but rather that there's something that we need to address before that. We need to be clear about what is relevant for us to, what relevant purposes we have to advance, as this is the basis of our jurisdiction. The Law Society Act says that applicants for licensing, lawyers and paralegals, are entitled to be licensed if they meet the qualifications and other requirements set out in the Law Society Act and in Law Society bylaws. The Law Society, as it's entitled and presumably required to do, has established such qualifications and requirements. One of the requirements is either graduation from an accredited Canadian law school or alternatively obtaining an NCA certificate. Because the Law Society can set qualifications and restrictions, qualifications and other requirements rather for licensing, the Law Society is in a very real sense the gatekeeper to the professions. Obviously, a central purpose of the exercise of the gatekeeping function is that licensees have an appropriate standard of learning. That's obvious to us all. If that's the only relevant purpose of what we're undertaking now, then our inquiry would be properly limited to an examination of whether TWU will provide or ensure an appropriate standard of learning from its graduates, such that a law degree from TWU should be taken as sufficient for demonstrating an appropriate standard of learning. My tentative view, given the work done by the Federation and what I've read, is that a TWU law degree will signify that a satisfactory standard of learning will have been achieved by its graduates. But I doubt that this is the only relevant issue for us to consider, particularly given Section 4.2 of the Law Society Act, which requires that in carrying out our functions, duties, and powers, one of which is accreditation, that we have regard to the enumerated principles set out in 4.2. So the question then is, if achieving appropriate standards of learning for licensees is not the only purpose advanced, what else is relevant? I think that it's clear that the Law Society has long considered that diversity in the legal profession and equality of access to the legal profession are of signal importance. Canada is a pluralistic society composed of different groups, different persuasions, in a sense, different tribes. One of the things about which we should be most proud as Canadians is that we have formed a free, democratic, and prosperous society that is not premised on one people, one culture, one tribe. Section 4.2 commands that we have regard to our duty to maintain and advance the cause of justice and the rule of law, and that we observe our duty to protect the public interest. I believe that the importance that the Law Society has placed on diversity in the profession and equality of access to the profession reflects in substantial part these duties. Our focus is in part on the rights of applicants to the profession and licensees, but I think our focus on diversity in the profession and equal access to the profession is more than that. The rule of law is one of the foundations of our ability to maintain our pluralistic society. But the law applies to all, despite our many differences and distinctions. The proper administration of justice is another foundation of the society we maintain. Maintaining and advancing the cause of justice depends on the proper administration of justice. The administration of justice must be accessible, irrespective of one's group or persuasion. Public confidence in the administration of justice depends on equality of access to that administration. It is virtually a truism that in our free and democratic and prosperous society rests on these foundations. The faith of members of our diverse society in our democratic institutions depends on the rule of law and equal access to the proper administration of justice. Reflecting on initiatives such as the Justicia Project, the Retention of Women Task Force, challenges for racialized licensees, it seems clear to me that we have concluded, and rightly so, that ensuring that there are no limitations to the entry to the practice of law, other than learning, training, and character, is important to these foundations to our free, democratic, and prosperous society. Reflecting on our shame that here and in other common law jurisdictions, Jews, blacks, communists, and others were once denied admission, I think is corroboration of this conclusion. Said simply, we are clear that qualifications and restrictions that would limit entry to the profession on the basis of one's race, religion, gender, sexual orientation, and the like would be inappropriate given the importance of the legal profession to the rule of law and the cause of justice in this diverse society. The legal profession must be diverse. No group can be forced to see their members excluded from entry or restricted from entry to the legal professions. To this point, I would have thought there would be no controversy. While we are gatekeepers to the profession, there is a gatekeeper before us. The candidates for entry to our licensing process are largely determined by the law schools. We are the gatekeepers at our stage, but we only consider law school graduates and NCA certificates. For every place in law schools in Canada, there's more than 3 applicants. The law schools are significant gatekeepers prior to the Law Society. With this observation, it seems to me that the Law Society should appropriately seek to ensure that these prior gatekeepers do not restrict entry to the legal profession, where the Law Society would not do so for the same reasons. My tentative view is that the Law Society should not accredit law schools that effectively limit or impair admission on the basis of race, creed, religious belief, gender, sexual orientation, and the like, because in part of the importance of the rule of law and the administration of justice and the pursuit of justice in our society. I say this not because of the impact on the applicant or the rights of the applicant, although I accept that those are other important distinctions. But my intent is to analyze this question from the perspective of our great gatekeeping role to the profession and the importance of a diverse profession and equal access to the profession in pursuit of rule of law and cause of justice. I recognize the analysis doesn't properly end there. Having considered our statutory purposes, we must consider charter values and the Human Rights Code. I'm not going to do that because there'll be a rich discussion about that. But I do want to recognize that we're presented with a Hobson's choice. Maintaining the principle that law schools should not be allowed to limit or impair admissions on the basis of sexual orientation and marital status, and declining to accredit will limit entry of religious candidates to the profession. This is truly unfortunate because, as I consider it, we should be equally pleased in our pluralistic society to see new evangelical Christian lawyers as much as LGBTQ lawyers in our profession. But it seems to me that we're entitled, and I think obliged, tentatively, to act in broad principle rather than counting heads and see which is the least bad alternative on the facts presented to us. The approach that we take here will echo into and shape the future, not just of this application, but applications generally. And public confidence in the legal profession and our willingness to support the rule of law, advance the rule of law and cause of justice will be supported if we take an issue as a principled matter. Finally, I'd like to observe that many of the submissions received on both sides ironically say the answer is plain and obvious and that they are shocked and appalled that we can even have a debate. Perhaps this is advocacy, perhaps it reflects deeply held personal views, but fairly reflecting on our legal responsibility, and if lawyers we can't do that properly, we should be concerned. And honoring the rule of law makes it clear that the decision before us isn't an easy one. The answer isn't obvious. Simply relying on our personal beliefs would not be right. The rule of law demands that we exercise our discretion in accordance with the jurisdiction granted, not to do just what we personally prefer. That's why my presentation and questions implicit in it are focused on our statutory duty in advancing the purposes of the Law Society Act. So I'll continue to reflect carefully on the submissions received and on the view of my colleagues. But as matters stand today, I would not accredit TWU because TWU's covenant unacceptably limits admissions based on sexual orientation and marital status. The likely standard of learning of TWU graduates is of no concern to me. I welcome their graduates as people. I fully accept that that law can properly be taught from the religious perspective, just as from various other secular perspectives. One need only reflect on legal history to know that many religious legal scholars have greatly contributed to our legal understanding. But like Mr. Mackenzie, as I stand today and before listening to the debate and the further submissions, I would decline to accredit. If conditional accreditation were an option open to me, I would be in favor of that. Thank you.
Thank you, Mr. Mercer. I think, given that the hour is just after 10:30, we'll take the morning break.